Good evening, I'm Barkha Dutt. You're with the Mojo Story. We are turning our attention today to the rape case at IIT Guwahati that has its students, its alumni, and in fact, men and women across the country up in arms. Let's bring up our big story today around the verdict that has everybody so angry. This happened after a rape accused, a student at IIT Guwahati, was allowed to walk out on bail. More worryingly, in fact, most worryingly, the judge, while decreeing the bail order, argued that both the accused and the survivor were future assets of the state. The accused lawyer was able to focus on his academic prowess and build a case for the judge to deliver in favor of a bail. But why should a rape accused be described as a future asset of the state or the country? The survivor, meanwhile, a young woman, has told Mojo Story that she feels slut-shamed, she feels sidelined, she feels discriminated against, and she feels fearful. This is what happens to so many women who actually follow the legal process while fighting rape, sexual harassment, and abuse. On the program today, we'll be looking at everything that we believe is wrong with the IIT Guwahati rape judgment, the bail, by the way. And what is important to mention at this time is that the judge, while ruling in favor of bail, also said that there was a strong prima facie case built out against the accused. So it wasn't as if the judge was not convinced about the prosecution's case. Ashok ji, how do you see this? You know, this is not a conversation only for women, to be had by women, for women, about women. This is a conversation that concerns men and women, and it should not matter whether the judge in question is male or female. That is the other important thing. The law must speak for itself. The judges must be sensitized. How do you see this judgment, Ashok ji? This order, I should say order. How do you see it, Ashok ji?
Barkha, this is absolute shocking. In my career of dealing with criminal matters for last more than 4 decades, I mean, I have never seen such a bad order. And it reminds me, there's nothing about bad CRPC or IPC or system. It is more to do with the mindset of the judge. I've been talking about this. Many judges have talked about this. This training of mind is most important, which is not being actually provided to many judges here. A judge saying this, I'm sorry, I beg to differ with Anjana Prakashji, that if charge sheet is filed, these are the reasons for ordinary crime, simple crime, not rape. There is a minimum punishment, 7 years. It is life. In these cases, rule is jail, rule is not bail. Bail is not to be granted unless there is a prima facie case that it is false. Here the judge is saying that prima facie case is there. And if IITian student and saying that he is an asset, he is a future criminal. I mean, see, if you see that this is the case, you say there is a strong prima facie case, then he is a future convict. That is why in these cases, unless there is a reasons to believe or unless there is a ground that this is prima facie false, although the judge is not to record that it is prima facie false, but the judge may grant bail, taking into consideration all these circumstances, I grant bail. But saying this, it reminds me in fact of Oscar Wilde, who says nothing worth learning can be taught. So what was worth learning, I am sorry, this judge has not learned. Oscar Wilde says,
so do you believe Ashok ji, that the Supreme Court must step in as it did with
something very important. Supreme Court judgment, the judge should have kept in mind, where the Supreme Court says that rape offense is not only against the physical body of the girl or the survivor, it is against the soul. It is against the soul. If that is the law of the land, that the Supreme Court says rape is against the soul, attack on the soul, should the judge say this so casually is saying, so casually? Yeah. It is shocking. It should be, I feel there should be a disciplinary action also. Somebody should report it to High Court that this man, this gentleman judge, you must see that whether he should continue or not. It has shaken the confidence of nation, of any man.
The person will be granted bail by the session judge, the High Court, the Supreme Court, but the magistrate will not be granted.
Okay, let's get responses. Okay, Ashok Arora, go ahead. Please respond, then Abha, then Poonam. Yes, Ashok ji.
Let me remind every participant, including Anjana Prakashji, I never said bail cannot be granted. I said normally bail is not granted. Then bail is not rule. Bail is not rule in case of rape. That I still repeat. And as far as disciplinary action goes, Milord, I still call you Milord. As far as disciplinary action is concerned, Justice Anjana Prakash, you are experienced enough. An order which shakes the confidence of the nation and the women in particular, or any conscience keeper, it is a good ground for the Chief Justice to refuse work, to withdraw judicial work. We know that it cannot be impeached immediately. But if you are to do justice to the system, immediately, if I was the chief, I would have withdrawn the judicial work. Okay, you sit at home or sit at your home, wherever. Or this is so shocking.
Arora, a lot of judges will say, thank God that you're not the Chief Justice.
This is a case for withdrawal of judicial.
In a lighter tone.
Let's get responses to this. We have literally a minute left, so 30 seconds each to Ashok, Abha, and Poonam. Ashok ji, we'll start with you.
Two things, Barkha. Number one, his mother also should be booked for threatening the witness. And number two, very serious thing, since they stopped the ambulance, all those boys or girls who stopped the ambulance should be booked under 307 attempt to murder. Because if the heartbeat was so low, so that means definitely she could die. If you stop the ambulance, stopping ambulance, actually it means here that they should be all booked, and including the mother who threatened. And if you threaten the witness, it is a good ground to refuse him bail till the end of the trial.